Hello and welcome to this News9 special. There is an animated debate that's happening in the Parliament, especially on the no confidence motion. Meanwhile, there is a very interesting bill that is going to be introduced in the Parliament, and this is Kabir with regards to the appointment of the Chief Election Commissioner. Now, a small background to it. Justice Kim Joseph's bench had gone ahead and said that the President will appoint the CEC based on the advice of the Prime Minister, the Leader of the Opposition and the Chief Justice of India until the Government of India made a law. Now, using that particular aspect, now a bill is being introduced in the Rajya Sabha first, where it's saying that instead of the CJI, you have a cabinet minister being added to it. Now, this has resulted in another controversy just in this monsoon session, which is already having a lot of controversy on the Manipur debate as well as how the economy is going. And just now we also heard about the Madurai Ames issue as well, which was taken up by Nirmala Sitharaman. And that had resulted in the opposition benches, in fact, staging a walkout, and the Treasury benches, in fact, going ahead with the debate in the Parliament on this. But to discuss more about it, over here in the studio, we have Kabir Naqvi joining us. And we also have our legal editor, Ashok Bagaria, who's also joining us on this. And well, I'll come straight away to Ashok Bagaria. Ashok, can you just explain the background of KM Joseph's judge order that he had given during that time, especially on the CEC? And now we'll also shall go ahead and discuss about how the provisions in the new bill try to actually dilute that order. But first, what are the circumstances that led to this case going to KM Joseph's bench then?
Well, basically what had really happened was that there were a bunch of petitions which were filed in the Supreme Court of India, and which raised the issue that as far as the appointment of the Chief Election Commissioner and the election commissioners to the Election Commission of India is concerned, there was a gap in it, in the sense that they said that there was no qualification for a person to be appointed as the Chief Election Commissioner, or for that matter, the Election Commissioner of India. That was number one. Number two, it was also, in those petitions, it was also told to the court that to ensure the independence of the poll body, which is the Election Commission of India, there should be a procedure which should be prescribed for the appointment of the Chief Election Commissioner and the commissioners. And both these two features were lacking in the Constitution of India and the rules and the Election Commission of India and the Representation of People's Act, which lays down as to how the appointment of the Chief Election Commissioner and the commissioners are to be made. Now, it was in March this year that the Supreme Court of India, in a landmark verdict, said that, look, we are convinced that we have to ensure that there has to be total independence of the poll body, because the poll body is burdened with a constitutional obligation to conduct free and fair elections. And if I can point out that in the recent times, the role of the Election Commission of India has come into sharp focus, and it has been criticized more often by the opposition parties and civil rights activists, saying that the Election Commission of India has not been acting in an impartial manner. So the court said that, look, to ensure that the people who come to the Election Commission of India, there should be a procedure in which they should be appointed, and there should be a minimum qualification or eligibility which must be laid down. So to do that, what the Supreme Court of India did was, in the month of March this year, it said that, look, we believe that there is a vacuum in law on the appointment of the CEC and the ECs. So what we are going to do is that till the Parliament of India makes a law in this regard, we are making an interim arrangement. And that arrangement will continue as long as the law is not made. And as per that arrangement, they said that the CEC and the election commissioners will be appointed by a collegium. The collegium will consist of the Prime Minister, the Leader of Opposition, and in case there is no opposition party, recognized opposition, then the single largest party in the Lok Sabha, the leader of that party, will be a part of that collegium, as well as there will be the Chief Justice of India, and these three people will decide on the person who could be appointed as the chief election commissioner or for that matter, the election commissioner, number one. Secondly, as far as the eligibility is concerned, they left out that portion and they said that there should be some criteria, some eligibility. It can't be a case where you pick up anybody and appoint him or her as the election
But
commissioner.
here in the new
So that
bill,
has to be
Ashok,
done.
just sorry to interrupt you, but in the new bill they are saying that, he should have served as a secretary of the Government of India. So it does not actually specify from which services that it is being used. How do you define that secretary of, even I was trying to understand that. Could you just throw some light on that, that the person should be a secretary to the Government of India? Is it opening up a vast scope or what is it?
No. So if you look at the wording of the bill closely, it says that the person shall have a minimum qualification that he or she should be a secretary to the Government of India, number one. And they qualify this requirement by saying that the person who will be appointed as an election commissioner should have some background of election related matters or dealing with the election issues in the past. So it can't be randomly any secretary who has in the past not dealt with any election issues. So basically only secretaries who have in the past, they have a record of having dealt with election matters or elections, of having conducted elections as returning officers or observers. Only those persons and who are secretaries can be considered for appointment as election commissioners. The second thing is that it says that the Government of India will draw up a panel of 5 persons. So every time one election commissioner is to be appointed, there shall be a panel of 5 people. And from that 5 people, these 5 names of these 5 people will be discussed by this collegium. Now, this collegium, which the bill seeks to create, will consist of the Prime Minister, the Leader of Opposition, and surprisingly, this time around, we see that the Chief Justice of India is not part of the collegium. And what the new bill says is that the third member will be a Union Cabinet Minister who will be nominated by the Prime Minister. And all decisions will be done by majority. So in the sense, what is really happening is that the very structure of the collegium which this particular bill envisages to create is lopsided in favor of a candidate that the Government of India favors. So there is likely, if this bill goes through, there is a likelihood that it could be challenged because the Supreme Court had in its March judgment said that we have to ensure that there is total independence and impartiality on the part of the Election Commission of India, and especially when we have a collegium where questions could be raised, that we have the third person who is again a Union Cabinet Minister who's nominated by the Prime Minister of India, then questions are going to be raised. And in fact, I believe that if this bill goes through, it will be challenged in the Supreme Court of India.
All right, Ashok, Kabir here, just, butting in before Varghese asks the next question, trying to understand, just like Varghese, what essentially this bill means to the common, folk out there. Now, you spoke about the March, observation that was made by the Supreme Court. And it's funny that today the CJI is out of that role in its entirety and a Union Cabinet Minister is going to make its way. We threw up those graphics that it's not the first time that, earlier legislative actions have undone Supreme Court decisions. We've got the 1951 example, the state of Madras versus Srimati Champakam, 1975 Indiran, Nehru Gandhi versus Raj Narayan, 39th Amendment struck down with SC for the first time, applying the principle of inviolability of the basic structure of constitution, and just like that, several other cases as well. 1978 Shah Bano, 2012 Vodafone Group case, the list does go on. The bigger question, it seems, right now here is, and a lot of people are already talking about it as well, there are comparisons that have been drawn with Netanyahu's, far-right government and their judicial overreach. The opposition has constantly been saying that the ED and CBI have been weaponized against the opposition members. Even today, Mallikarjun Kharge in the Rajya Sabha said that, haan, Pradhan Mantri aa rahe honge, Paramatma thode hain. So all of that, politics is also taking place. The bigger question is, apex institutions of our country, aren't they going to be in conflict with each other when things like these happen? Number one. And number two, do you see this hardening the stand of the Supreme Court in the days to come as well? Because challenging is something that you put out, but a Supreme Court taking a harder stand, legislative actions and doing Supreme Court decisions, and it's not just about Parliament versus Supreme Court. Apex institutions coming at loggerheads because of these kind of conflicts and confusions.
Well, to answer your second question first, as far as the role of the institutions in this democracy is concerned, you have to understand that the Election Commission of India is as important an institution as the Supreme Court of India, because it is primarily tasked with the obligation of conducting free and fair elections, and free and fair elections are the bedrock of any representative democracy. So here, what the Supreme Court had done in March was to say that there is a lacuna in the law, because this is possibly the only position, along with the National Commission for Scheduled Caste, where there is no procedure which is laid down for the appointment of the chairman or the chief election commissioner and the election commissioners. So what the Supreme Court said, that what we are going to do is that we are going to fill, there is a vacuum in law. We are just going to fill it up by saying that there should be a collegium body, number one. Number two, I don't think that there's going to be any kind of a conflict, although you rightly pointed out that in the past there have been numerous instances where the Supreme Court verdicts have been overreached by the governments of the days, and they have brought in laws to overreach the judgments. And in fact, I would like to point out that even let's not go back to 1951. It's happened as early as this year itself, when the Delhi Services Bill was introduced by the Government of India. In fact, what the Supreme Court had done was that the Supreme Court had in its earlier judgment said that as far as services are concerned, the services will be under the control of the Delhi government. Now, to overreach that verdict, the Government of India brought in first an ordinance taking away the appointments and transfers and posting of bureaucrats posted in the National Capital Territory of Delhi, taking it away from the Chief Minister of Delhi to the Lieutenant Governor of Delhi. And what we saw after that ordinance was that now a bill was introduced and it has been passed and it has now become a law. So this kind of a conflict has always been there and will always be there. But institutions are not going to come into conflict with each other, because as far as the court is concerned, the court is very clear that its role is about the interpretation of laws. Similarly, the Election Commission of India also has to be very, very clear that their job is to conduct free and impartial elections in this country. Now, what the Supreme Court is doing at this point in time is just ensuring that what the Constitution makers envisaged or imagined or visualized for a good working of this democracy called India, right. They had envisaged that the Election Commission of India should be free and an impartial body. So the Supreme Court, by its March verdict, has only reinforced that view and said that, look, what we are going to do is that as far as CECs and ECs are concerned, they shall now be appointed by a collegium body. The glaring omission of the Chief Justice of India in the latest bill is there, and in fact, the Government of India will come up for very sharp criticism for omitting it.
Right. Thank you, Ashok, for in fact joining us with all those details and giving us an insight about it. Kabir, also, we are in fact enlightened on what was actually happening when it comes to this bill. Very crucial, in fact, when it comes to the CEC, as we have 2024 elections.
I think we'll have to wait and find out, as what Ashok was talking about, in the challenges that are now going to be done.
No, exactly. Once if the bill is in fact becomes an act.
Yeah.
So till then, it is going to be a big question that will always be there as to how this bill will unfold. But that's all the time that we have. Stay tuned for more on the other side, especially on the jailer mania. With that, it's a wrap from my side.
He thought he could outlast us.